Today on Inside the Issues, I speak with Maria Panezi on the subject of carbon pricing and the World Trade Organization. Hello and welcome to this week's edition of Inside the Issues, the CIGI Online podcast. My name is Dr. Andrew Thompson. I'm an adjunct assistant professor of political science at the University of Waterloo and senior fellow here at the Center for International Governance Innovation. Every week, we're joined by an expert in global governance or international public policy here to the studio in Waterloo. Today, my guest is Maria Panezi. She is a postdoctoral fellow with the International Law Research Program here at CIGI. Welcome to the show. Just so that we're all on the same page, what is carbon pricing or carbon taxing?
Carbon pricing is one of the methods to account for carbon emissions during the production of commodities, of goods. So factories, when they produce any kind of goods that we all know and buy at the store, have a carbon footprint. Essentially, they produce CO2. The burning of fuel produces CO2, and that is detrimental to the environment as it accumulates. So carbon pricing is a way to hold those who produce a lot of CO2 accountable in certain ways, at least monetarily. So it basically is a way of evening things out a little bit, at least economically.
And in Canada, we have kind of a patchwork framework for dealing with carbon emissions. Mm-hmm. Can you say a little bit about the lay of the land here in Canada? Yes.
First of all, Canada is even progressive in what they're doing with respect to carbon pricing. Even with the very fragmented picture we have, it's still way ahead of other countries. It started with British Columbia that put a straight up carbon tax on carbon emissions with respect to energy, to gasoline. So that tax has been around for a while. And at first, there were some sort of worries that this was going to cripple the British Columbian economy, but it never materialized. In fact, BC is doing great. Other ideas that have been floated were the ideas of cap and trade that were recently actually adopted.
So in Canada, we have a bit of a patchwork approach to dealing with carbon emissions. Could you say a little bit about the various initiatives that are happening across the country?
Yes. Currently, British Columbia has a carbon tax. Ontario and Quebec have a cap and trade system. How are these different? The carbon tax is a straight-up tax on gas in British Columbia. The cap and trade system that exists both in Quebec and Ontario is essentially a system that says if you're emitting more than 25,000 tons of CO2, then you are given a permit that puts a cap on how much you can emit. And if you're emitting less than your permit, you can actually trade with others that emit more. The idea behind such a system is to incentivize companies to lower their carbon emissions in hopes of selling them to others that emit more. And also, progressively, as this occurs over time, the government will start lowering the cap, so overall CO2 emissions will go down. Quebec and Ontario are also part of the Western Climate Initiative, which includes California and the United States, essentially extending this trading regime amongst multiple parties. So that is the hopes of that existing is to multiply the effect of this system. So that's sort of the patchwork. These are the only places that, and also I think Alberta also has a carbon tax. But I think it's different in nature than the one in BC. But the idea is that there's no pan-Canadian approach to pricing of carbon. Only certain provinces have stepped forward and done things. But since the Paris Agreement that took place that was signed in Paris in December 2015, the Canadian government has committed to do more. What that means is a complicated question. What does it mean to do more for the Canadian government? And at this point, they have gathered in Vancouver at the beginning of March to commit to a strategy for a common framework, for a common plan. So nothing is in place yet at the federal level. There's just a commitment to figure out solutions that can be pan-Canadian.
And are these carbon pricing mechanisms, are they fundamentally compatible or incompatible with our legal obligations to the World Trade Organization, for instance?
Well, with respect to domestic emissions, Canada is a sovereign country, and they're free to do as they please. The Paris Agreement commitments are, how firm they are, we're not sure yet. I mean, the agreement is really recent. It hasn't been actually, the formal signature process is going to happen in April in New York. So we don't really know what our obligations with respect to emissions per se are. So with respect to our domestic emissions, we're free to do as we like. The issues with international trade start when we are trying to impose our standards on others. When products come to our border and we have taxed the same product domestically, there is an inclination to treat those products the same, which starts causing the problems. That's where we get into a little bit of a hot water territory with respect to the WTO, because we are allowed to do certain things according to WTO law, but we're not allowed to do others. And there is a question mark on whether we can or cannot impose a similar carbon obligation, whether it's tax or cap and trade. That's needs to be debated, but it's not clear whether we can impose the same obligation to our foreign counterparts when they want to trade with us.
Now, the World Trade Organization has historically been fairly cautious on questions of environmental enforcement. Mm-hmm. Why is this the case?
Well, they have been controversial for a while, and they fall under the general rubric of process and production methods. Process and production methods is not the good itself, not the commodity that you see in your hands, but what went into making it. So why is it controversial? Think child labor. Okay, this is a perfect football with the small stitching, but a child made it. Is it okay to trade in a country that explicitly prohibits child labor? Then we get into debates of whether if we prohibited child labor in other countries, what would happen for that economy? There's basically zero agreement on that. And as a result, process and production methods become a taboo issue. Right. With respect to climate change, there's been a lot more will to litigate, let's put it this way, even though we still haven't clarified what is our approach towards the environment, what is the WTO's approach towards the environment. Still, the cases have been looked upon from the dispute settlement body of the WTO. So what are cases like that? What do they entail? Basically, imagine fishing. Fishing tuna with methods that are detrimental to certain species in the sea. And shrimp. Those are two famous cases. The shrimp and the shrimp turtle case and the tuna dolphin case are two famous cases in the WTO. The results are always, how should I put it? They're always a little timid. Even when the WTO wants to take an environmentally friendly approach, it's usually buried in long cases that have a lot of legal complexity. Right. So in order to unearth whether the WTO is environmentally friendly or not takes an expert. So it's not exactly straightforward whether they are or not. When it comes down to their political rhetoric with respect to process and production methods, those are explicitly left unexplored because countries will not agree on them. So we're still essentially in a little bit of an unknown territory with baby steps that are hidden in complex legal documents.
Right. Now, countries under the WTO framework have the ability to sue other countries for what is deemed to be discriminatory practices. Is this system with the WTO at the moment inhibiting action on climate change?
Action on climate change with respect to domestic producers, Canadian producers, absolutely not. Right. Canada can take any measures with respect to its own people, its own goods, its own factories, its own corporations. The problem starts outside. And discrimination is a complex thing in the WTO. You cannot discriminate like products in a way that you favor your domestic products. If you keep the playing field level, though, things start getting a little bit more open towards regulation. So the process and production methods and the environmental measures tend to be a little trickier because you can't exactly prove what happened into what was put into producing a certain product. But if, let's say, we had a fully transparent program, a fully transparent process, and Canada could plausibly demonstrate that those two products were produced in the exact same way and they emitted the exact same CO2 and we're treating them exactly in the same way without giving a leg up for the domestic market, then I think this would go just fine with the WTO, especially considering the last decade of case law, which is a little bit more friendly towards the environment.
Right.
I think the WTO is ready to embrace this. The problem comes with the way that national legislation is designed, that oftentimes it tends to contain discriminatory provisions. So when you do get before the WTO, you might have legislation that looks good up until a certain point, and then you have a provision that's discriminatory, like the feed-in tariffs, the Ontario domestic requirement. So then the WTO has their hands tied. This is a flat-out discrimination. They can't but reject it. That doesn't mean they wouldn't be okay with it if Canada or Ontario hadn't included that clause about domestic requirement. Right. So it's sort of a balance. It looks like the scale of justice, right? It's kind of a balance between how much can you do without end up discriminating against your foreign counterparts. And I think that careful environmental law design can achieve that target, but it requires a lot of domestic debate to get the provinces at the same level, and then it requires a careful design of the law itself. Why do we need, there's the question, why do you need that careful domestic debate? It's a practical reason. For the international organization, for the WTO, it doesn't matter if a product was produced in British Columbia or Ontario or Prince Edward Island. It's irrelevant. Right. The product is Canadian. So if you have a product in British Columbia that is accountable for its CO2 emissions and has a certain tax and it's all nice and proper and clean and accountable, and let's say 99% of the Canadian market is such products, but then there's this one product somewhere being produced that is not accountable, the foreign product coming in will not be compared to the 99%. They'll find that one product and they'll say, but look, this is discrimination. There's a Canadian product inside Canada that has an advantage over us. Right. That's the kind of mentality that exists behind the WTO case.
And is part of the problem that the WTO cases that it have been ruled on just are ambiguous? I mean, do we just I guess what I'm asking is, over time, as more and more cases are argued before the WTO, will the rules of the game become clearer for everybody?
Oh, that's a great question. I think that would be the ideal scenario for any legal system, be that international or domestic. You let time and the rules be elaborated on and you get to a better interpretation. That would be ideal if you didn't have domestic protectionism. Oftentimes those measures are such a great platform for those who want to protect domestic industries through the back door. And just cushion them from global competition. So that's what's, I think, inhibiting the problem. And in order to solve the protectionism issue, we can't just trust this timely process, this time-consuming process. What we should trust is another type of process, one that's more assertive, one that comes in and clarifies the rules in advance and says this is what our approach is with respect to environmental regulations. And that hasn't happened. A genuine discussion on environmental rules has not happened in the WTO. In fact, the closest approximation is what is currently occurring with the Environmental Goods Agreement, which has not been signed and is being discussed in the WTO. It's an agreement to lower tariffs on goods that are considered to be environmental. And I'm putting it in quotes because that's a category that we don't have consensus as to what belongs in it or not. Solar panels? Yes. Bicycles? Not so sure. So hybrid cars, are they in there? Are they not in there? Do they actually produce CO2, therefore they're not part of the environmental goods? There's a lot of debate on what fits in there and what not. I think that a great tool to understand it, the way I try to understand how these things are being negotiated sometimes is really practical. I'm thinking, is there any kind of hypocrisy in what you're trying to figure out? So an example is, are you trying to figure out whether bicycles are an environmental good? And at the same time, do you have a shipping industry that's so large, it's producing so much so-called black carbon that, come on, bikes would never solve this problem. So you often have to look at this with a little bit of a sense of irony and an eye for hypocrisy to understand what is at stake there. So it's also reflective of the problem why process and production methods have not been clarified on. It's a road you don't want to take because if it does get clarified, you might have less opportunities for protectionism. But it's also a road that others don't want to take because if we include this, there might be more grounds for protectionism. So essentially, you do have to rely on the goodwill of states and on a firm understanding that this is a real problem that they have to tackle. It's not something that they can use for the next 40 years to give a leg up for their cement industry, for example. No, this is a real problem. You have to phase out cement, and you have to go into a commodity that's far less carbon intensive.
Right. Now, the World Trade Organization has said that environmental protection is a legitimate area for state intervention. Can you say a little bit, what exactly is the position of the WTO on this?
That's correct. So there's two areas where you can locate the environment in those agreements, in those WTO agreements. First, you can find it in preambles. Right. When countries sit down to write an agreement, they have this little goodwill text at the beginning before they go into their actual commitments, and protection of the environment, sustainable development is part of that. So it's there. It's there in those very words. But inside the agreement, it's more hidden. So where do we find it? There is an exceptions article inside the General Agreement for Tariffs and Trade, which is the main document for the WTO, or one of the really important ones. And there's a number of exceptions on why the WTO could let you violate, either briefly or for a longer time, your commitments with respect to non-discrimination. It's a very technical test to meet, so you have to still do it in a non-discriminatory manner, but there are grounds. So you can restrict goods and their imports for reasons of public health and animal and plant health, public morals, natural resource conservation. That's the one that seems to be closer to the environment. And there's other reasons that you can, there's actually a very long list of reasons on why you could restrict trade, but you still have to do it in a non-discriminatory manner. So to look at this practically, imagine the mad cow disease that occurred a while ago in Europe. For a while, when things were still unclear where this will go, how much will it affect our health and whatnot, you could say as a country, oh well, I'm going to restrict imports from Europe, or at least I'm going to hold them at the border until I test them. So it is putting a burden on that product coming from Europe, while let's say the one from Argentina is just waved in or much faster. That's a legitimate reason. It's a legitimate concern. And each of those legitimate concerns has a different legal story behind it. Others have been litigated on much more elaborately because they appear more often. Others have not been litigated as frequently, like the one about natural resources. So what I would argue here is we shouldn't restrict ourselves or our legal imagination to one of them. Yes, natural resources appears to be the closest one, clean air being the natural resource we're looking at, but I think that we could also play the public morals card, not in a manipulative and calculative way, but we could argue as lawyers that our public morals evolve towards environmental consciousness. We could also play the human health justification. Potentially, if you look at this as a security issue, there's an additional article that discusses security exceptions. It could go under that one. And I really I'm very pro not restricting our justifications, but looking at them all and trying to see how each one of them could play, because there is room for that, and narrowing it down is not necessarily the best thing.
Right. Now, just a final question. I think it's fair to say the World Trade Organization has been suffering from a bit of a legitimacy crisis.
Yes.
Is helping to enforce climate legislation, climate-friendly legislation, a way for the WTO to, in a sense, reinvent itself or rediscover this lost legitimacy?
I think that there's two aspects to answer this question. The one is a little bit more moral, and the other one is a little bit more economic, it's a little bit more cold-hearted. I'll start with the moral one. I think that there's a lot of legitimacy in tackling current problems, current big problems, and the WTO doesn't seem to be, the organization seems to be stuck in political issues they don't seem to have the capability of solving, like the development issue and how to include developing countries, while keeping climate change at a back burner, not giving it the proper attention, how trade affects climate change, having a genuine discussion on it. So I think by switching gears into the 21st century problems and taking this as an opportunity to fully engage with the developing countries is a huge, huge moment for them. And if they let it pass, now that the iron's still hot from the Paris Agreement, I think it's to the further detriment of the organization, not being able to produce a proper, meaningful agreement. Now, going to the economic argument, there's a lot of debate or a lot of talk about the trade facilitation agreement in the WTO. If you compare the numbers between what would be the impact of a proper environmental goods agreement or what the impact of carbon emissions are on our economy versus what the impact of that tiny agreement is, the numbers are very different. You've got basically peanuts on one side and you have multi-billion deals on the other. So it's much more important for our economies to look towards dealing with climate change today than trying to get consensus on micro agreements of the yesterday.
Right. Maria, thank you so much for being on the show. This was absolutely fascinating.
Thank you too.
And thank you to our audience for joining us. Please join us again for another episode of Inside the Issues, a CIGI Online podcast. Look for us online at cigionline.org, on Facebook, on YouTube, and on Twitter. Today on Inside the Issues, I speak with Maria Panezi on the subject of carbon pricing and the World Trade Organization. Hello and welcome to this week's edition of Inside the Issues, the CIGI Online podcast. My name is Dr. Andrew Thompson. I'm an adjunct assistant professor of political
emissions during the production of commodities, of goods. So factories, when they produce any kind of goods that we all know and buy at the store, have a carbon footprint. Essentially, they produce CO2. The burning of fuel produces CO2, and that is detrimental to the environment as it accumulates. So carbon pricing is a way to hold those who produce a lot of CO2 accountable in certain ways, at least monetarily. So it basically is a way of evening things out a little bit, at least economically.
And in Canada, we have kind of a patchwork framework for dealing with carbon emissions. Mm-hmm. Can you say a little bit about the lay of the land here in Canada?
Yes. First of all, Canada is even progressive in what they're doing with respect to carbon pricing. Even with the very fragmented picture we have, it's still way ahead of other countries. It started with British Columbia. that put a straight up carbon tax on carbon emissions with
Science at the University of Waterloo and Senior Fellow here at the Center for International Governance Innovation. Every week, we're joined by an expert in global governance or international public policy here to the studio in Waterloo. Today, my guest is Maria Panezi. She is a postdoctoral fellow with the International Law Research Program here at CIGI. Welcome to the show. Just so that we're all on the same page, what is carbon pricing or carbon taxing?
Carbon pricing is one of the methods to account for carbon with respect to energy, to gasoline. So that tax has been around for a while, and at first there were some sort of worries that this was going to cripple the British Columbian economy, but it never materialized. In fact, BC is doing great. Other ideas that have been floated were the ideas of cap and trade that were recently actually adopted.
So in Canada, we have a bit of a patchwork approach to dealing with carbon emissions.